I'd like to talk today, though, with Mark Chenoweth. He is the Executive Director and General Counsel of the new Civil Liberties Alliance, and you can check that organization out at their initials, nclalegal.org. That's nclalegal.org. Hey, good to have you back, Mark. Good afternoon.
Good afternoon. Thanks for having me.
Thank you. Let's your view on this. I mean, there are a lot of people who are very concerned about the thought of the court being packed. Some are saying, hey, look, we're just exploring the idea right now. Any harm in what's now happening, or do you think this is a precursor to ultimately adding members to the Supreme Court? And if it is indeed, then what are the practical steps it would entail?
Well, I do think it's very harmful, Drew. I think it's deliberately intended to be harmful. It's intended to be a shot across the bow and to influence the deliberations of the court, including Chief Justice Roberts, who has shown a certain propensity to bend to this sort of external pressure in the past. And I'm afraid that that is the point of the convening of this new committee, regardless of what recommendations they might make in the end. But I did want to, listening to the intro there, I did want to maybe take issue with one thing, if it's okay with you.
Sure, no, go ahead.
I'm not sure I agree that Congress has the power to increase the number of justices of the Supreme Court. Article 1, Section 8 gives Congress limited powers. One of those powers is the power to, quote, constitute tribunals inferior to the Supreme Court, unquote. Mm-hmm. Right. So under the limited powers of Article 1, Section 8, Congress does not have the ability to constitute the Supreme Court, only the inferior tribunals. And then you might say, well, how did they do it in the first place? We can get into that. I think the necessary and proper clause has something to do with that in a way at the beginning that wouldn't be true today.
Well, explain that.
But there are a couple other usual things.
Yeah, explain that in greater detail, because my understanding is that the Constitution didn't fix a number of judges, and it has changed in the past. So how does that number change? Maybe give us a little history lesson here. When did it change? What fomented that change? And what would have to happen to see the court either expand or shrink? And constitutionally, what is needed to meet that criteria?
So originally it was 6, and I think that they figured out pretty quickly under George Washington that having an even number of justices wasn't such a good idea. So it jumped to 7, and then there was an effort early on during the Andrew Jackson years to change the number. But the big change came around the time of the Civil War, when Andrew Johnson was president, and you had, obviously right after Lincoln was assassinated, you had a Democrat vice president in Johnson who became the president. The Republicans still controlled both houses of Congress. They didn't want President Johnson to make appointments, so they prevented that temporarily, and then restored that when Ulysses Grant became the president. But we've had 9 justices since the time of Ulysses Grant. You mentioned increasing with the growth in the size of the country, and that's what happened when we increased from 7 to 9. And I should have that exact year, but I don't have it in front of me. But that was as a result of growth in the population of the country, and the justices themselves were asking for that increase, because you may remember that justices used to do what's called riding circuit. They would go around the country and hear cases, and that was hard to do as the country got bigger.
Yeah, so what are the issues right now? I've heard some people say, hey, why is everybody getting upset? This is exploratory. What are the issues that the commission that President Biden set up, what are they going to look at besides just adding members? Term limits, et cetera. But what are they examining? What is problematic? What might come from it?
Well, none of those things are constitutional, right? So term limits would be directly contrary to Article 3 of the Constitution, and would require a constitutional amendment. So if anything that they're coming up with is to propose a constitutional amendment, then that would be the legal way that you would have to do it. If they're trying to propose something short of a constitutional amendment, then I'm going to be pretty concerned that they are trying to do an end run around the Constitution. And I think that any efforts in that direction will really compromise the independence of the judiciary. In terms of things that are being proposed, it's, as you say, they're talking about potentially adding justices. They're talking about term limits. I've seen a whole lot of different ideas thrown around, including say, having a fixed number of years for a justice that can't be renewed. So, for example, each justice would have an 18-year term or something like that, where it would be long but not lifetime. But again, all those things would require constitutional amendment, because there's a lot of steps in the Constitution to protect the independence of the judiciary. It's not just the lifetime tenure. It's not just the inability to reduce the salary. There are a half dozen other provisions that we don't talk about as often that are in the Constitution to preserve the independence of the judiciary. For example, a Supreme Court justice cannot serve as an elector in the Electoral College.
That's fascinating. So what did you think of Justice Breyer, Stephen Breyer, who came out recently saying that packing the courts would be a bad idea? As soon as he said it, people started pressuring, they started a campaign, actually a pressure campaign, to have him retire. Because, of course, they would love to have Joe Biden, nominate somebody else for the court, because it would be a slam dunk. What was his reasoning against court packing? We played a little bit of it, but your thoughts on Breyer and his position, Ginsburg and others. I mean, where are Supreme Court members, those who were on it, those who are on it, how do they feel about this as well?
Well, one of the things that Breyer said was that that the court operates based on trust, that's a very important factor, that the court's authority depends on, quote, a trust that the court is guided by legal principle, not politics, unquote. Right. And he said that structural alteration motivated by the perception of political influence can only feed that latter perception, further eroding that trust, and end quote. And so, I think that he's very cognizant as a sitting justice of the real handicap that would be put on the court's authority by anything that made it look like it was being motivated by politics rather than legal principles. He's very, I think, appropriately wary of these sorts of efforts to intermeddle from the outside. In terms of what other justices think, I don't think anyone else has been particularly vocal about it. I haven't seen, right. Maybe you've seen something else. I haven't seen anything recently along these lines. But I know that there's been talk of a constitutional amendment to fix the number of justices at 9. I don't think there would be anything wrong with that, but that would also require a constitutional amendment.
9 seems like a good number. It's a nice odd number. It seems to have worked for as many years as we've had it so far, and we'll see how all that ultimately pans out. I don't know if anything will ever come of this. There's a movement from liberal sources now to add more district courts. People are claiming, hey, we have an increase in population. The increased population requires more courts. Is that an accurate statement? And how does that work? Do you think we'll see more district courts? And what other factors are at play here by adding more district courts?
I think we will see more district courts, and that is within the power of Congress to do that, and they've done it many times before. Oftentimes, they wait too long to do it for political reasons because it's hard to get a bipartisan agreement to do that under any president. The last time there was a huge increase in the number of judges was under Jimmy Carter. There have been some increases since then. And I think if they're serious about doing it, they should spread those out over a 6 to 8 year period so that it's less likely that all of the new judges would be appointed by any one president.
Yeah, that makes sense. All right, well, let's take a few calls for you. We only have a few minutes. My guest today, Mark Chenoweth, if you want to join us, we're talking about court packing, or expanding the court, I should say, and how that's done and whether or not it will become a reality. The number here, if you want to get in, 888-914-9149. Mark is listening in Chicago. He wants to join the conversation. Mike is listening in Chicago. Mark, he wants to join the conversation and has got a comment for you. Hi, Mike.
Hey, Drew. How you doing? Great program.
Thank you.
It's my opinion that these progressive liberals, they worship at the altar of abortion. And that could be threatened by a conservative court. Of course, it would be kicked back to the states, right? I mean, the feds can only do so much. But I really think this is their fear, and at least that's what they're telling their constituents, that you have a conservative court and they're going to take away your abortions. And I really think that's what's driving it. It's this underlying evil battle that's going on.
Yeah, Mike, thank you for bringing that up, because that's a key part, I think, of the conversation here, too. And the court has been fought over in past decades, Mark, over this issue of life. We saw the appointments or the nominations of the past president, President Trump. Your thought on how this issue of Roe v. Wade and life plays into what we're seeing in terms of where the Dems are right now and wanting to expand the number? Are they fearful that we have a conservative, number on the conservative number of justice, and that a case might come before them that could challenge Roe v. Wade? I mean, what are your thoughts on the whole pro-life, pro-choice Roe v. Wade issue in determining some of the movement that we're seeing here with this dialogue and with this action?
Well, it certainly appears to be the case that that's what the Democrat elected officials are saying and are telling their base as one of the motivations for what they're doing. But of course, Roe v. Wade came out of a Supreme Court that was dominated by Republican appointees, including Eisenhower and Nixon appointees. The Casey decision in the early 90s came from a court that I believe had 7 of the 9 justices who were appointed by Republican presidents. So we've been down this road before of people assuming that because some fraction of the justices were appointed by Republican presidents, that means that Roe v. Wade is in jeopardy, or that pro-life sorts of decisions will be forthcoming. Haven't really seen that pan out. So that whether that's a convenient political argument or something that's a genuine possibility, I'm not sure.
So I have a moment or two left. Just finally, this commission that the president has set up, are there any people on it who are favorable to conservative principles, or is that not the case? I mean, I don't. You may not be able to answer this question. Do you know what the composition of this is? Yeah, I'd love to hear it.
I do. I've looked at it pretty closely, and there are a handful of folks on there who I think you could call right of center academics. William Baude from the University of Chicago Law School is generally thought of as right of center. Keith Whittington from Princeton is generally thought of as right of center. And Adam White at George Mason, I guess the Antonin Scalia School of Law and AEI is generally thought of that way. Thomas Griffith from the D.C. Circuit, recently retired from the D.C. Circuit Court of Appeals, was a Republican appointee to that circuit. And so you do have a few folks, but the vast majority of the folks on the committee are left liberal academics and activists, right? So you have folks who are, I should have mentioned Caleb Nelson, too, from the University of Virginia School of Law. He's generally right of center. But the rest of the folks are left academics or left activists, including people like Michael Waldman of the Brennan Center at NYU and Sherilyn Ifill at the president and director of the NAACP Legal Defense and Education Fund. So it's a fairly stacked panel in terms of not 100%, but certainly more than 2/3 of the folks on the committee are kind of things from a left of center or extreme left of center perspective.
Wow. Well, it will be telling to see how this pans out. A final thought here as we wrap it up. How do you think it is going to shake out in the end? And again, you can't read the future. You don't know what's in the minds of these people. But if you were a betting man, what do you think is going to come from this?
Nothing.
Really?
If I were a betting man, I would, because it takes a constitutional amendment to affect change, and I think that's going to be very difficult. I think I would be surprised to see a bipartisan recommendation come out of this commission for something short of a constitutional amendment. In other words, I don't think that you're going to see this group of folks put their stamp on some of the radical progressive ideas that have been put forward as sort of shortcut ways of packing the court.
So it's a big waste of time then, fundamentally then. That's That's good to know. Well, Mark, thank you very much for your time. I'm grateful for it and always enjoy having a good conversation. Mark Chenoweth is the Executive Director and General Counsel of the new Civil Liberties Alliance. Check them out at nclalegal.org. I'd take a short pause.